first year article clerk at Lionel Murray, Schwarmstead and Lowe, which is a medium-sized law firm in the heart of Cape Town, specializing in media, corporate and entertainment law. But also, I'm an ex-Stellenbosch Art Law Clinic member, but full-time present hype girl of SALC. And I've been a part of the Art Law Clinic since its growth, since its inception, and been part of its growth and journey. And it started in about October 2021. Just a little bit about me. My interest in IP really began in my first year property law lecture. And I remember just sitting there in class thinking how cool it was that a person can acquire rights, intellectual property rights, with regards to their creations of their mind, right? And then a step further than that, they can then protect those rights. And then beyond that, they can enforce those rights with specific remedies available to them should their rights be infringed. And I think intellectual property is playing a really increasingly fundamental role in the economy, as it's the primary mechanism with which authors, programmers, inventors, artists, and other creators are able to exploit their work for commercial gain. And this makes sound understanding of intellectual property and intellectual property law an essential for any commercial or corporate legal practitioner and artists and creators alike. Enough about me, more about the actual Stellenbosch Art Law Clinic. Like I previously said, we were initiated about 2 years ago by our German associates at the University of Munster. Our plan was and is to create and foster a relationship where art students could come and receive free access to legal information. That way, our law students get the chance to get real hands-on experience in the industry, and artists, can have a place to go to when they find themselves with any legal or practical questions. Our work and key milestones is our art law handbook, which I had with me here a second ago. Here it is, which has just been recently published. Very proud of it. It's been recently published with the great help of our German and Stellenbosch University supervisors. And this book really, it aims to guide artists in the realization of their rights and to inform them of the law in relation to IP rights, contracts of sale, MOUs, which are Memorandum of Understandings, contracts with art galleries, and insurance law. But essentially, at our core, we are a student initiative with 90% of our operation run by 30-odd students themselves, all with a passion for both art and the law. And currently, our clinic is slowly developing into two parts. And the first path that we're sort of growing on is an information sharing path. So every so often, we will give lectures to the art faculty at Stellenbosch. You'll also find us online on our website and Instagram page, where we write and share various blog posts on numerous topics. The most recent being a post by one of our members, Husna, who wrote an article about how artists can avoid ownership disputes with regards to their creations. We have also been offered a permanent monthly lecture spot at GUS, the Gallery of the University of Stellenbosch, and there we give lectures and host panel discussions and workshops. And finally, we are just legal researchers. So if you have any questions about a specific issue, or you want to just find out more about whatever it is that you're going through in the art sphere, we're there to help you and literally do the research on your behalf. And the second path that we're sort of on as a law clinic is to grow our operations. And so we're currently in talks with various law firms about their collaboration with us, and where we hope to open our doors as a pro bono legal service provider. And events such as this one actually really help us get that exposure and our name out there so that we can help as many people as possible. But without further more to do, I hand over to Genevieve, who is our founder and chairperson of the Art Law Clinic.
Hi guys, thanks for having us today, and Mvelo, thank you for a wonderful introduction. So as an art law clinic, we do mostly legal research, so we were stuck with all the very contentious grey areas to talk about tonight. We'll be covering artificial intelligence and NFTs and how those might relate to the art industry and how it might affect you as an artist. So yeah, we're going to speak briefly about NFTs, but I think the bulk of it is in relation to artificial intelligence, just because it really is taking over the industry quite quickly. So I think before we get into the nitty-gritty, maybe it's worth seeing what's actually going on with AI in the art industry. I'm actually doing my thesis on AI copyright and if we protect AI-generated works in copyright, which is proving a lot more difficult than I thought. But I read a very interesting article the other day that said every day artificial intelligence generative AI systems are making 15 million images, and it took photographers 150 years to create the same amount of photographs from the day that the first photograph was taken. So to put that into perspective, how quickly AI is really generating these works. So, I don't know if you've heard about the next Rembrandt. This is one of, I think, the most phenomenal AI-related artistic works that have come out in the last few years. So, it is actually a 3D printed painting that was generated using AI technology that trained an AI system on hundreds, if not thousands, of Rembrandt works, and it was able to actually understand the stylistic preferences of Rembrandt and create an artwork completely new that obviously wasn't painted by Rembrandt but looks exactly like it could have been. So you'll see it uses, I think Rembrandt used to use chiaroscuro lighting, so it uses the exact same lighting techniques. It's really, you can't really tell the difference, and because it's 3D painted, it doesn't really exist in a technological forum, it actually exists in real life. And this was in 2016, so if we think that AI is something new, it really has been going on for quite a while. Then we have the portrait of Edmund de Bellamy. This was the first AI-generated artwork to sell at auction. It sold at Christie's for over $400,000, which is roughly 8 million rand. Now, the reason for me that this is so contentious is because it's not really certain whether there is copyright in AI-generated work. So if you are selling a painting like this for 8 million rand, what are you selling? And as someone who's buying, what are you buying? Okay, so what is artificial intelligence? It can get quite technical. I mean, we deal with artificial intelligence every day. Your predictive text on your phone is artificial intelligence. Your Netflix recommendations are also artificial intelligence. But where it's becoming particularly contentious and amazing, actually, is where it comes to generative AI systems and machine learning. And machine learning refers to the ability of a machine to learn from itself without any human input. That is like, for example, if we look back to the next Rembrandt, where the machine itself learned what those commonalities were between the images it was being fed, and developed its own understanding of how Rembrandt created his works. So it's important to differentiate between 3 different types of artificial intelligence. We have artificial narrow intelligence, which is where we are right now, and that's where artificial intelligence can create within a specific within specific parameters. Then you have artificial general intelligence, which is the next stage that I think everyone is trying to hop into, which is where it can really imitate human intelligence, and we're not there yet. I think the jump from going from ANI to AGI is huge, because that means that artificial intelligence will be able to think better than we can. And as we know from, I'm sure everyone has experimented a bit with AI and ChatGPT, there are limits on its abilities, and you can quickly figure out how to outsmart it because it doesn't really display a nuanced understanding, or it doesn't really understand nuances. So yeah, and then we have artificial superintelligence, which is when robots take over the world, which I don't think is going to happen because we can just unplug them. So, but I'm a law student, not an IT student, so I don't know how true that is. But so yeah, artificial neural networks. This is very cool. I found this out the other day, months into my thesis research, how AI actually works. And it's through what is called artificial neural networks, which replicate the way that the human brain works. So how we have neurons firing when we pick up certain stimuluses, AI works the same way. So it is extremely labor intensive to train an AI system to be able to generate things that are as proficient as like the next Rembrandt. Basically what happens is you have an input layer where you as a human would give a prompt, and then it actually will value your data based on what you're looking for and what it has in store, and it will continuously value your data, basically refining what your question was against what it has in its data sets, and it will give you the most statistically accurate outcome based on that. And if you, I think, try and understand that from a human perspective, it's experiencing something, using all your years of experience of what that thing is and how it works to be able to understand how you're going to react to it. That's the premise behind AI, is I think, like I said, to replicate human intelligence. And that's essentially what the Turing test is, which is the test for gauging whether you are dealing with intelligence, and that is if the person using the artificial intelligence doesn't know that they're using AI and thinks that they're actually communicating with a human being, then it is deemed that that thing is artificially intelligent. So yeah, it's a very fast, very accurate statistical analysis of data. Why should you care as an artist? AI means that anyone can be a creative, and I think, as we saw from Arinda's discussion earlier, your copyright is where you make your money as an artist. A lot of licensing agreements can bring a lot of money into you as an artist, and I think if anyone can be a creative, why would you pay for it? Why would you pay for a graphic designer if you can do it online for free? Why would companies outsource someone else to do something if they can do it in half the time and at half the cost? So, the two main questions when it comes to AI, the AI contention, and I think as it would relate to an artist, they do relate to copyright. The primary one is there even copyright in an AI-generated work? And the second one is whether there is copyright infringement when AI is trained on your artwork, for example, or in the style of your work, to be able to generate similar works. I think it might be worth briefly going over why we have copyright, what the purpose of copyright is. Copyright is very much a balancing act of rights between the public interest to have access to works, you don't want to gatekeep, and then there's also the rights of the author or the owner of the copyright, who will have exclusive rights to exploit that work however they wish for a limited period of time. So it's often referred to as a limited monopoly. But a very long time. I mean, we saw earlier that it can be 50 years plus the lifetime of the author in the case of authorial works, which we'll get into later. But that's a long period of time. I mean, that's why rock stars' children can live off all their royalties long after they've gone. So we have entrepreneurial works and authorial works in South African law in copyright. I know we've just done copyright, but it's quite important to understand this, to understand the implications it has on how we regulate AI. So authorial works are your traditional works that you would think of when you think about creation. So you would think about literary works, you would think about artistic works, dramatic works, musical works, and then entrepreneurial works are works that vary a little bit from traditional copyright. They are often based on the authorial work, so like a sound recording or a broadcast, and there you would have a different type of copyright protection just because of how South Africa has chosen to regulate or incorporate entrepreneurial works. In Europe, entrepreneurial works are not recognized in copyright. Copyright is strictly for artistic and literary and musical and dramatic works, and then those other works like entrepreneurial works, where much of what actually is done is very mechanical, and it's difficult to prove that originality requirement that we spoke of earlier. Because it diverges from copyright, it isn't protected in copyright, but rather under what they call related rights. So you'll get a different period of protection. Your period of protection won't be calculated in reference to the lifetime of the author, because the author doesn't really do much. It's mostly a corporate investment. So entrepreneurial works and related rights typically are there more to protect the investment and not so much the labor or the author behind the work, because sometimes it's difficult to find who that author actually is. So in South African law, we do have a provision that recognizes computer-generated works, which would be like AI-generated works. The problem is that the Copyright Act also tells you what works are eligible for copyright protection. And that's what we spoke of earlier. You can see literary, dramatic, musical, whatever. But in the definition section of who an author is, there's an exception in paragraph H that says the author of a computer-generated work, or a computer-generated literary, dramatic, musical, or artistic work, is the person making the arrangements necessary for the creation of the work. So very clearly, computer-generated works are not a separate category of works eligible for copyright protection, but rather an exception to how authorial works like literary, dramatic, musical works operate. So in the case that you have a literary work or an artistic work that is computer-generated, then the author isn't going to be the creator anymore, which means that's the person who gets the copyright in the work. The author is the person making the arrangements. And that's the same terminology used for entrepreneurial works. So it looks like it would be the company, it would be OpenAI who would have copyright in every generated work that comes out of ChatGPT. And that does not sound like something that you would want, considering that your justifications for copyright are supposed to be this balancing act that strikes this balance. I mean, the primary purpose is to afford copyright because you want to incentivize people to continue creating. And number one, it's doubtful that there is even this need for incentive for people to use AI. They'll use them anyway because it's more efficient. And copyright is not the reason that AI is developing the way that it is. So, yeah, it doesn't really look like it's something that should even be recognized in copyright if we also consider the fact that AI can churn out millions and millions and millions of works in a second. I mean, it's, yeah, anyway. Then I think as an artist, because there isn't clarity on whether we actually do protect computer-generated works, despite the fact that we have said we protect computer-generated works, it's important to differentiate between computer-aided and computer-generated work so you can tell as an artist when something that you do would likely be something that has copyright in it or when it wouldn't. Just something that I forgot to say that is quite integral to this is that because there is no separate section of computer-generated works existing as a separate category of eligible works, the period of protection that would apply to computer-generated works is the same for normal literary, dramatic, and musical works, which is the lifetime of the author plus 50 years. And since we've already established that the author is the juristic person or company who is responsible for the system itself, there would be no copyright because a juristic person cannot, you can't calculate copyright for the lifetime of the author plus 50 years of the juristic person because it would exist in perpetuity. So it's actually implied that there is no protection for computer-generated works. I know it sounds very technical and legal, but it's actually a very important thing to understand because if you are using AI in your artworks, or if you're trying to sell something like, where is it? That's why this has no copyright. I mean, this sold at Christie's in the UK. The UK law and South African copyright law is verbatim the same. The only difference is that the UK is regulated a little bit more, but there's similar issues there. So arguably, there isn't even copyright in this image, and someone bought it for 8 million rand. So what did you buy? I mean, you'll see in all my images, I put the image from question mark, question mark, question mark for all of them because never mind the fact that there's no copyright infringement for educational purposes. There's no copyright infringement because there's no copyright in the image itself. Okay, back to how you as an artist can maybe be a little bit more aware of how you use AI technology. Computer-generated works, as we've seen, are not protected in copyright, but computer-aided works are, so that's where you would use a computer system or an AI system to help in or assist in some way in the creation of your work. So I reference here to Amazon. I think it's important to note that what the law says and what user guidelines might say on platforms where you might want to sell your works electronically are different. And where you have things that the law stipulates, what a website like Amazon, for example, would stipulate is a contractual agreement. So if you are going to sell your works with Amazon online, you're contractually obligated to comply with their user terms and conditions, whereas what the law says is a lot more broad than what those agreements normally say. So I definitely advise, if you are selling your works online and you have used AI at all, just to see what their user agreements are. So for example, work in South African law is computer aided, where there is still significant human contribution. So if a human being has still contributed significantly their own skill and labor to making something, even though they may have used AI in some form of the process, or they've used AI and they've built over it and over and over it, and I would argue if you have a very, very detailed, specific prompt that you give to an AI system, that there is sufficient skill and labor in that itself, and then what the AI generates is simply mechanical, and that you would still have copyright in that. Whereas what Amazon says is not that. Amazon says anytime you make use of generative technologies, it is AI generated, and then you have to inform them, because they place limitations on how many things you can publish if you have AI generated the work. So, as you know from earlier, the sweat of the brow test is what we use in South African copyright law to determine whether the person is the author and whether the work is eligible for copyright, and if it has this originality element. And if you have not, if the majority of the work has actually been done by the AI and what you have contributed as a person is trivial, then it will be computer generated and you'll have no copyright in that image. So that is a very, 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 very thin line to be walking. So I would just be extra careful when it comes to AI. I mean, it's so much fun to play with, it really is, but don't be fooled by any means that you might have copyright in that. And then internationally, it doesn't look like anyone's even recognizing copyrights and computer-generated works, especially in the US, which is, I mean, yeah. US is always a bit funny, and yet they're the ones who are being more conservative here. So these are the two cases that were really big in the US this year: A Recent Entrance to Paradise by Stephen Thaler. The US has this requirement for you to register your copyright. We said earlier that you don't have to normally register your copyright. It's automatically vesting, but they do require it. And their compendium, which just sets out the guidelines of what can and can't be registered, is very clear that anything that is computer generated is not eligible. And they use the term, I think, computer generated or machine automated is not eligible for copyright, because copyright only vests in human authorship. So anyway, Recent Entrance to Paradise, Stephen Thaler actually created the creativity machine that generated this work, and there was still no copyright in the image itself because it wasn't generated by a human being. Then, you must please excuse my attempt at French, the Théâtre d'Opera Spécial was generated using Midjourney. This was the most recent case. I think the judgment was only made in like July or August of this year. Also, no copyright. I mean, it's a beautiful, beautiful work, but there's no copyright in it. So, if you're putting effort, or I mean, even if you are putting effort into generating something like that with very specific prompts, you know, like I said, it's a very fine line to be crossing. So, then we have Zarya of the Dawn by Christina Krashimova. This, I think, relates quite nicely to the example that we used earlier of a wonderful chicken in a cookbook. There is copyright in compilations. So even if the subject matter that you are compiling doesn't have copyright in it, you will have copyright in the compilation. So here, the images were also generated using Midjourney. But if you've ever gone online and taken a squiz at the screenshots of the actual comic, it's beautiful and it's wonderfully written. It's definitely, there's artistic merit in it, but not in the images itself, in the storytelling and in the comic. So there was copyright in the compilation, but not in, and in the literary works, but not in the actual artistic works. So as an artist, if you are doing some kind of like mixed media, I guess as a compilation you would have copyright, but in the individual artificially intelligence generated works you wouldn't have anything. And then onto the second issue of whether there would be infringement where you are training AI on existing artistic works. I mean, this is extremely controversial because I think there are a lot of parties lobbying for both sides. I mean, the US is very pro access to information and anti-gatekeeping, and they have a fair use exception that we don't have. We have fair dealing, as we said earlier, which is where there are very specific limitations on what is an exception to copyright, like we said, for educational purposes or for private use. Whereas in the US, there is a general exception to copyright, and there are certain criteria that you look at in determining whether there is fair use, but that is only done once the case goes to court, and no one is going to court over trivial copyright issues. Copyright issues happen on the daily. We had a case maybe like 2 months ago over 150 Rand. It was a girl who came to us who had been creating little digital figurines and selling them on her Instagram. And her bio said that they were for profile pictures, and someone bought one for 150 Rand and then started using them on t-shirts and selling it on t-shirts. But she didn't specify, again, contract law, she didn't specify that if you want to commercialize the works that there's an additional fee or that she should get royalties from that. And so he just continued, and she couldn't do anything about it because no law firm is going to take a 150 Rand case. It's not worth their time or money. And even you as an individual don't even think it's worth your time or money, just let it go, you know. So if that is the day-to-day issue that we are dealing with in copyright in South Africa, introducing fair use, which is going to come with the new amendment bill, is going to be a bigger issue because now no one's going to court, and now there aren't these clear delineated exceptions to copyright. Now it's a very general exception, and that's why the US, I think, is largely anti-copyright for AI-generated works. But also, there is this talk of maybe introducing data mining licenses, so where if a company like Google, for example, wants to train its systems, or if Midjourney or OpenAI wants to train its systems, that they would have to enter into licensing agreements with artists to use their works to train their systems, which I think is more than fair. But then some countries, I think it's China, I think China doesn't, or has an exception when it comes to data mining, which means that there is no copyright infringement when it's used for data mining purposes. And in the US, there is also this exception for data mining because they have fair use, which is a general exception. And if we look at, for example, what happened in the Google Books case, basically Google infringed millions and millions and millions of copyright works. I say infringed, the court didn't say it was infringement, because they photocopied books and then posted them on their Google Books platform. And all the artists said that this was a copyright infringement because they should have entered into data mining licenses with Google. And Google shouldn't have had the right just to copy their books. And Google argued that they're not actually posting the full textbook online. What they're doing is they're posting an excerpt of the textbook so that the student or whoever's looking for the book knows when they type in whatever they're looking for on Google and the textbook comes up. They know exactly where they'll find it, they know what page it's on, but they don't get access to much more of the work, and so they're encouraged to buy the work. So essentially the work has been transformed. They're not actually copying the actual textbook, and their line of commercializing the product is very different. So where you would look to buy the book from an author, what Google does is they said actually encouraging people to buy the book from the author, even though they have still photocopied all these books, put them online. And I personally have used Google Books a lot in my thesis, and I've not paid for a single book. So So that was it on AI. I just wanted to go through it quite quickly. I mean, it's very contentious, and you can spend hours speaking about every little facet of it. But I hope it wasn't too boring and too technical. And if you have any questions, we will chat about them at the end. But I am going to rush through NFTs because NFTs are more like the funky pair of shoes that you bought that you never actually wear. Like, that's NFTs. So NFTs stand for non-fungible tokens. I think no one really knows what fungible means, so maybe we can just go into what fungible and non-fungible mean. Yes, it's Roman law. So sorry to the lawyers, I have to learn again. But fungible good and a non-fungible good differ in that a fungible good is exchangeable, whereas a non-fungible good is not. So for example, if I enter into a contract to buy a bag of corn, I'm not buying that specific grain of corn, I'm buying corn, generally speaking, and it's replaceable. If that bag of corn that I wanted to buy falls off the truck, I can just get another one. That is something that is fungible, whereas NFTs refer to non-fungible things. So an artwork, I think, is non-fungible. Okay. You're going to have to excuse my attempt at explaining a blockchain, but how I understand blockchains, and I actually got this from an IT friend of mine, is that it's like a service manual for your car. So it's the same reason that there's such a hype around cryptocurrency, because it's supposed to be extremely safe and bulletproof technology where information is unalterable, when it exists on this blockchain. So yeah, it's like a service manual for your car, and it basically will keep track of every sale, every contractual variation of a contract, if you want to include resale royalties in your contract and put that on the blockchain, all of that is unalterable. So you'll see exactly, if you buy work, for example, an NFT online, you'll be able to go and trace back where it was originally purchased, who else has bought it, what the price increase or decrease was. And in that way, I think it's the reliability and it serves as verification purpose, where you can verify what you're actually buying is the thing that you say you're buying. So that's where I think it can be quite great. Any digital work can be, which is capable of representation in graphical form, can be an NFT. So you can have an NFT in a photograph, you can have an NFT in a video, in a tweet. But I think also it's important to distinguish the fact that that image is not an NFT itself. It's the metadata associated with that image. That is where the value of the NFT actually lies. So again, this is where another thing gets contentious. When you buy an NFT, you are not buying the intellectual property rights to that image. So people, I don't think anyone really understands how NFTs work, so no one really is too sure what they're buying. And again, if you're not buying the intellectual property, then what are you buying? You're buying this chain of metadata. But what is the value of that data? The only value in it is being able to resell it at a later stage for a high price. So, yeah. I think NFTs can be quite controversial because there is it works a lot like crypto, where there aren't any economic indicators that affect how you value the NFT. It's strictly supply and demand. So it's extremely fickle. And that's why I think as an artist, I mean, it's awesome to experiment with, and there are some benefits which I'll get into now, but it's a terrible market if you're a buyer. It's quite a fun little playground if you're an artist, but yeah. Okay, how can you benefit as an artist? So I attended a lecture by Marion Dixon from Strauss & Co. And she was speaking about how difficult it can be when it comes to the secondary art market and doing valuations of works, because now you have to go back and see, was this work created by this specific artist? Was it created in this good era of theirs? Is it an original? Is it a copy? It's so difficult to make sure that what you're actually selling and the price that you're selling it for is representative of the product itself. And that's where NFTs can be really great, because like I said, it's this like indestructible chain of history of that specific artwork. So another thing, like we spoke about now, the fact that we don't have resale royalties in South Africa yet, you can very easily include that in your blockchain, in your contractual terms, and automatically every time that NFT is sold, you will still get your resale royalties. So that's where it can be quite great. Also, again, a nice platform if you don't want to engage with art galleries. I mean, I know it's quite intimidating to be getting involved with galleries, and I know it can be I know that there's quite an imbalance of bargaining power as well, because the galleries can look at everyone and take whoever they want, and you're just kind of thrown out on the street if you aren't good enough or don't agree to their terms. So this is where it can be quite great for experimenting. But like I said, I wouldn't really take it too seriously and put my money in it. But that's just my personal opinion. How is it looking? So I think here is why I don't think it's great to be involved in too deeply, because the Bored Ape Yacht Club, one of their NFTs, the highest it sold for was $3.4 million, 65 million rand. For what? What are you buying? Just that chain of metadata. And now there is an 88% drop in floor price, where you can buy them for like $200,000, which is still a lot of money, but we'll get into the big Sotheby's metaverse lawsuit that related to that. So yeah, let's get into that first, I think. So Sotheby's has a metaverse on their auction site, which is where they sell AI-generated artworks and where they sell NFTs. And there was a big case that came out, I think in August of this year as well, where Sotheby's were accused by Bored Ape Yacht Club investors of falsely inflating and creating false hype around NFTs. They apparently made misrepresentations to people in the auction market that NFTs had made their way into the mainstream auction world and that they weren't so much of a novelty. driving interest obviously in NFTs when that wasn't the case. But also cited alongside them was Justin Bieber and Paris Hilton, who've also been accused of falsely inflating and falsely creating hype around NFTs. A few celebrities have been charged with huge fines and big penalties for also creating this false hype around cryptocurrency. So I think it's exactly the same issue when it comes to NFTs. Market in South Africa. So South Africa, I don't know too much about the art market, but from what I have understood about it and learned about it this year is that it's quite a few steps behind what's going on internationally. So the market for AI-generated works is not very big here. The market for NFTs is not big here. A friend of mine from Stephen Waltz & Co., he just said to me that they tried to do a standalone sale for NFTs and it completely bombed, and they're just not even going to consider it again, and this was last year. But then he did point me in the direction of one of the sales that Strauss & Co. did of the world's greatest wines. And they didn't do a standalone NFT sale, but what they did is they sold an NFT minted according to the specific wines that they were selling, and the NFT then served a verification process, a verification purpose, where you could verify that the wines that you were buying were provenance reasons. It is the wine that you say you're buying, and it's this very old, valuable wine. And then they also served as tickets, so you can almost buy an NFT for a future wine that's going to be made in a year's time or 2 years' time. So I think the artistic side of blockchain technology like NFTs is a bit superfluous to what the real value of blockchain technology really is. I think it's just the fact that it's unalterable. Excuse my language, am I allowed to swear? It's completely unfuckwithable because you really can't. It's bulletproof, and I think that's where it's great, but I think everything other than that is just people with a lot of money playing around with things that they can. So yeah, that's it. I think that's it for all of us. Thanks, guys.